Coming up later on Air Talk, one of the stranger stories that we've come across in the past couple of weeks, and that is that the U.S. Food and Drug Administration may require a nutritional label on pure maple syrup and honey that labels them as added sugars. Now, how does it end up that they're added sugars, essentially our sugar? We'll talk about that coming up a little bit later on the program. But first, a bill in Sacramento from Democrat Nancy Skinner of Berkeley that would narrow the scope of what's called the felony murder rule, which says that if you were involved in a crime where someone ends up being killed as a part of that criminal endeavor, you can face murder charges even if you didn't pull the trigger, even if you're not the one who stabbed someone. That if you're part of that crime, which ends up in someone being killed, you can be prosecuted as though you are the trigger person. With us is the policy director for Restore Justice, a nonprofit advocating for criminal justice reform, Kate Chatfield. Ms. Chatfield, thank you for joining us.
Thank you very much.
So your organization, the co-sponsor of this SB 1437. Why do you think that the scope of the law should be narrowed and that people should not find themselves potentially liable for murder charges here?
Well, you correctly described the felony murder rule, and in California, the felony murder rule is a very ancient doctrine. And as you stated, that a death may be accidental, unintentional, or unforeseen, but as long as it occurred during the course of or even the flight from certain crimes, all participants are liable for first-degree murder. In California, a first-degree murder sentence is 25 years to life. And in our criminal justice system, everywhere else, it is a bedrock principle of the law and of simple fairness that a person be punished for his or her actions according to his or her own level of individual responsibility and not for the actions and intentions of another. So this is why this ancient rule that we have, that the California Supreme Court 35 years ago called it barbaric and called upon the legislature to abolish it, that is why we feel that this rule needs to be addressed. And to be clear, we are not, SB 1437 does not abolish the felony murder rule.
Well, let me take a hypothetical example just to make sure that we understand it. So let's say you have a getaway driver drive to the scene of a robbery. The driver stays in the vehicle, and let's say perpetrators of the actual robbery go into the business and something happens and someone is killed as a result of that. Is the getaway driver in a case like that automatically charged with first-degree murder, or is it up to prosecutorial discretion and a jury's discretion as to whether the getaway driver would face murder charges in that case?
All charges ultimately are up to the prosecutor. The prosecutor decides the charging instrument, what they charge that defendant with. Under this rule, a prosecutor can charge and does routinely charge that getaway driver with first-degree murder under the felony murder rule.
And then a jury could decide whether they think that's justified or not, right?
The jury is instructed that they do not need to consider that getaway driver's intent or their actions vis-a-vis the killing. The jury is told, don't worry about that. So long as that person had the intent to aid and abet the burglary or the robbery, you don't need to decide whether that person should be liable for first-degree murder.
We're talking with Kate Chatfield. She's an adjunct professor, University of San Francisco School of Law, and policy director for the criminal justice reform nonprofit Restore Justice. They're co-sponsors of this bill carried by State Senator Nancy Skinner of Berkeley that would narrow what's called the felony murder rule. Also with us is Los Angeles County Deputy District Attorney Eric Siddall. He's the vice president of the Association of Deputy DAs. Mr. Siddall, good to have you with us again.
Thank you for having me.
Before we get to the broader issue here, I just want to follow on this specific scenario that I described. In this case, could the jury decide that the getaway driver is not liable for first-degree murder, even if prosecutors are pushing for that?
Well, no, I think the professor's correct in that she, in terms of her explanation, the jury is told that they have to the aider and abettor has to share the intent of robbery, but you don't have to share the intent to kill. So that is correct, and the reason is that there's certain types of activities that we consider inherently dangerous felonies. Remember, it doesn't apply to every single felony; it only applies to certain select felonies for first-degree murder and other types of felonies that the courts have determined to be inherently dangerous felonies.
Okay, but I'm still a little unclear. So can a jury, despite the instructions that they're given, that the getaway driver didn't have to be involved in the shooting that led to the murder directly, but could a jury come back and decide we really don't think the involvement of the getaway driver was facilitated the killing enough that that individual should be convicted of first-degree murder? Do they have that latitude?
I mean, a jury can always do whatever they want. If they're acting within the law, no, they can't. They have.
Okay.
If they're following the law, they're going to do exactly what was just stated before.
Okay. And then from your perspective, why do you think a narrowing of this law would be a mistake?
Well, my problem with the law is how it's drafted right now. And the reason is because right now, felony murder is basically a strict liability theory. That if you commit certain inherently dangerous felonies like rape, carjacking, arson, reckless use of a destructive device like a bomb, that you're automatically, and you're engaged in that type of activity, you're automatically going to be on the hook for it. The problem also with the bill, though, is that it also attacks another doctrine, and that's called the natural and probable consequence doctrine. That is a fact-driven argument that prosecutors use, especially on gang cases, to prove that other gang members who are not the actual triggerman involved in a murder. So I'm not sure if the drafters intended this, but it very much gets rid of the natural and probable consequence doctrine, which does allow a jury to look at the facts and is very fact-driven and allows the jury to say, hey, this activity that you were doing is so dangerous that the foreseeable consequence of what you're doing can lead to death.
Okay, so let's say you have gang members that are planning, let's say, to rip off a drug dealer. And so, the group of gang members descend on the drug dealer's house, and someone in the gang ends up shooting and killing someone at the drug dealer's house. Is the argument in this case that there is a probable consequence that with an armed group of people going to the drug dealer's house, there was a high probability someone would be seriously injured or killed, therefore everybody is potentially guilty in the gang?
Yeah, your participation in this whole thing, it's foreseeable that what your actions in this can lead to death. So it's a less blunt instrument than the felony murder rule in that it's another way, a theory of liability that holds people accountable for their own actions. And the problem I have with this bill as it's written is, although they keep talking about felony murder, it also gets rid of that that theory of liability as well.
All right. We'll continue our conversation. I'd love to hear your thoughts about this. Do you support the legislation? Do you think that this should be narrowed so that people who themselves didn't commit the actual killing of someone, so that they should not face first-degree murder charges if they are involved in the illegal activity, which then involves someone being killed? How much of a chain do you think there should be there when it comes to criminal charges? We're at 866-893-KPCC, 866-893-5722, or the Air Talk page, kpcc.org. We're going to hear from a listener who was actually convicted as a part of the felony murder rule and served more than 2 decades in prison. You're listening to Air Talk on 89.3 KPCC. We're debating a bill by Democratic State Senator Nancy Skinner of Berkeley that's designed to narrow the scope of what's called the felony murder rule, a long-established principle in law that says that if you are involved in a crime in which someone ends up being killed, that even if you weren't the trigger person, even if you weren't directly the individual who killed the victim, that you can be charged and convicted of first-degree murder because you had an involvement in setting up the scenario which ended in someone's death. What do you think about that? We're at 866-893-KPCC or the Air Talk page, kpcc.org. We're joined by LA County Deputy DA Eric Siddall, who's VP of the Association of Deputy District Attorneys. Also with us, University of San Francisco School of Law adjunct professor Kate Chatfield. She's the policy director of the criminal justice reform nonprofit Restore Justice. Ms. Chatfield, I wanted to ask you about what we just heard from Mr. Siddall. He said that also this bill would do away with the probable consequence doctrine in which you have a group of individuals, say gang members, carrying out a crime, and that you wouldn't be able to hold additional people accountable for a murder that one person carries out. Your response to that?
Sure. Well, the natural and probable consequence of this legislation is that all actors who commit a crime will be held fully accountable for their actions and for their intentions. Nothing more and nothing less. And this bill limits the application of the felony murder rule to those who actually kill and those who also aided and abetted the killing with the intent that a death occur. So those who, and we actually broadened the language in amendments that were taken so that anybody who aids and abets a killing, who encourages, who coerces, who induces, who counsels, who commands, who solicits, who requests, or who assists in any way the actual killer is still liable for that first-degree murder charge. Anybody who acts as a major participant in the felony with reckless disregard for human life is still liable for first-degree murder. So I don't want to get this discussion derailed with talk about gangs or criminal street gangs or, any other sorts of language that one could use to sort of obfuscate the issue at hand, which is holding people accountable for their actions and for their intentions.
If someone is involved though in a criminal activity where they weren't directly involved in the murder, is it also justice to only charge, let's say the getaway driver scenario again, to only charge the individual with driving a getaway car for a robbery as though it's any other robbery, as opposed to one where someone ends up being killed? Is that justified?
Well, there are. Let's take the example of the getaway driver. I think what's also being lost in this is that person is liable for, and Mr. Siddall was absolutely correct that there are only certain enumerated felonies where the felony murder rule applies, and so that getaway driver is liable for a strike offense and years in prison, and a judge is given or a sentencing court or jury is given the discretion to, if the fact is found that a death occurred during that, there is a what we call a triad of options.
So it could be I'm a little short on time, but just clarify. So it could be a greater charge if there is a death that occurs in the carrying out of the crime, that the getaway driver could face a more serious charge.
That's correct. It's a specific.
Okay.
Factor.
All right. Let me take a listener call. Robert, where are you calling from?
The South Bay.
Where in the South Bay are you calling from?
Gardena.
Gardena. Okay, thanks. Go right ahead.
Okay, hello, my name is Robert. In 1992, at the young age of 16 years, I committed an act of robbery with other juveniles, ages 4 to 17. The plan was strong-arm robbery with no weapon. After the commission of the robbery, one of our co-defendants stabbed the victim one time, which was fatal. During interrogations, I admitted to my participation in the robbery and was told by police that I was going to now be charged with first-degree murder. When I pleaded with the police that I never planned to murder someone, I was told that it didn't matter because of the felony murder rule. So I was essentially charged with first-degree murder. I received a sentence of 25 years to life. I served 21 years, and I got out at age 37.
And how long ago was that, Robert?
4 years ago.
You got out 4 years. What do you think would have been a fairer sentence for being involved in that crime which led to someone's murder?
If I would have been sentenced to what I committed, because in no way do I say that I was innocent, but I should have been charged for the acts that I committed and knowingly committed. The murder, there was no intentions or no malice aforethought or anything to indicate to kill someone, because we didn't want to kill anybody. We just wanted some money during that time.
So, Robert, do you feel as though the fair sentence would have been only for the commission of a strong-armed robbery, or do you think there should have been enhancements in your sentence because someone was killed, even though you didn't directly participate in that aspect?
Or just in my case, just the fact that we're all minors and we're all juveniles, I should have been sentenced to the crime I committed was strong-armed robbery.
Just to that, okay.
Instead of to the adult prison system.
All right, Robert, I appreciate your call. 866-893-KPCC or the Air Talk page, kpcc.org. Jessica in Fresno calling. Jessica, good to have you with us.
Oh, thank you. Thank you.
So what do you think of this bill?
Well, I am in support of Senate Bill 1437. My fiance is directly impacted by the felony murder rule. In 2002, as a minor at the age of 17, he was involved in aiding and abetting a robbery, and he was actually transported to the site of the vehicle as it was stripped of its parts after the carjacking had took place, and he was dropped off at a location to aid and abet while 3 adults were stripping the vehicle of its parts. During the commission of that robbery, someone ended up dying, and he was off-site. He wasn't there. He was probably about 2 to 3 miles away from the site of the crime, and he was tried as an adult in adult court and was convicted to 25 to life, and he's currently still serving that sentence.
Wow, so he was 17 during at the time of the robbery. How old is your fiance now?
He is going to be 33 this August.
And was he your fiance at the time, or did you get engaged to him while he was in prison?
At the time, we were boyfriend and girlfriend for 2 years. We were high school sweethearts, and no, we were not engaged. That didn't happen until the last few years. So
you're looking at potentially 9 more years or longer before he's released?
Correct.
Wow. Jessica, thank you for sharing the experience of your boyfriend. We're at 866-893-KPCC. We go back to Eric Siddall, Vice President, Association of Deputy District Attorneys, he himself an LA County Deputy DA. Eric, your response to these last two calls.
Well, let me just say, the reason why I brought up the gang issue is because I'm a gang prosecutor. That's all I do is gang homicides. And I think one of the unforeseen consequences of this bill, because I think it's a bill that's pretty poorly drafted, is the removal of the natural and probable consequence doctrine. That's going away with this bill. So they have to address that. The other issue is, in terms of these, a lot of these, your two callers were both youthful offenders. I find it very suspect that they're saying that they're going to have to serve the full 25 years to life because under a new law that was created, I believe, either January 1st of 2018 or the year prior, that they can get released early under the youthful offender law. So I'm not sure that these stories are quite accurate. I think that one of the problems with this whole debate is that they use very extreme examples. Perhaps a better method of doing that or of solving this issue than completely getting rid of accomplice liability is to have the governor look at certain cases and use his power to intervene, but simply just to get rid of the felony murder rule and to get rid of natural probable consequence and basically allow anyone that's engaged in very highly dangerous activities to skate away.
All right.
I think is inappropriate. It's inappropriate for victims who were victimized by these crimes.
I need to wrap, but I thank you. That's Eric Siddall, LA County Deputy DA, Kate Chatfield of Restore Justice, the criminal justice reform nonprofit, the organization co-sponsoring State Senator Nancy Skinner's bill, which would significantly narrow what's called the felony murder rule. You can share your comments as well as personal stories on the Air Talk page.